That's what it's saying. All right, so let me see if it came over now. This is crazy. I've been sitting here all this time. It says that it's streaming, but I don't see it still. I'm here and it still didn't link. I'm live. Like we're updated. We're not updated because it's not. I don't see it on my YouTube channel. This is crazy. If I reload. Oh, it says live now. Let me see. Where's this one at? Oh, there it is. Oh my goodness, y'all. For always, hey, you know what? I don't know what's going on. I'm in the for always. You hear me now? I don't know what's going on. I've been live since 10 o'clock. Okay, so now we're connected. It wasn't connected before. And because Allie was in here, but I had Pisces in there. You know what? I'm gonna just have to start this over. So what's up? What's up? I don't know what happened. The video wasn't connected, but I can see now that it's connected. So I'm like, wait a minute, what is going on? So hey, for always, life be life, and uh, bear with me. We do have an update in the Naziah Harris case. I was here at 10. I don't know how that is just weird. I was here at 10. We started to hear. I started to hearing and everything, but then I know. So I'm like, no, wait a minute. I wasn't, and I sent Allie a message. So let me just start this over because I don't think that you were here. So we have an update. So there was a hearing held for Jarvis Butts, and it's the we're saying it's the yeah, I don't know what happened. It was something with the the streaming platform, and it wasn't loading to the YouTube. But and I have been live since 10 o'clock, so I was here. But then I wasn't seeing any. It's weird because I see Ali's and Pisces comment from when I started, but then it just wasn't linked. I don't know what happened. So I'll just start the video over because we wasn't too far into it. So update for this case. He had a hearing. So we all, when we look at the case, we look at it as the Naziah Harris case because ultimately this is what kicked off this case. But he is being he has a hearing, and it was for the victim who was 4 years old. They have a motion to quash regarding that victim. So at the time she was a victim, she was 4. She's and she's 13. And I was just saying, just in case it didn't get picked up before, I couldn't be a defense attorney defending and I know it's our rights, but I wouldn't be able to defend the likes of Jarvis Butts or Diddy, or I just wouldn't be able to do it because my moral compass is just all over the place. Just like it's triggering, like the questions that you're asking. This child who was 4 years old at the time that he victimized her, and I think this is the child that at 4 years old he gave the STD to the midi, yeah, to, and now she's testifying and she's 13. She's still a child. So to me, you're up here arguing a point about I don't know. It's just it's triggering. My moral compass is just like it's just going off like. And I get it. You hit it. I just wouldn't be able to defend. I wouldn't be able to defend. You know him. It's just me. It's just me. But and they should be able to remain professional because that is what they do, and he has a right to a defense. But I think it's the I'll start the video so you will hear uh what they're arguing down to a little detail. The child was traumatized at 4. At 13, the child is still a child. And I get it. He's saying something about what he's arguing. There had to be some type of penetration or whatever, but penetration doesn't have to be with his private. It could be with his hands. But I guess they're trying to, like, the small little things they're trying to take away from that. Like I just wouldn't be able to do it. But shout out to Judge Aaron, and I said this earlier, the Submarinian, for keeping Diddy where he needs to be. I say round them all up. Go, go and start at the White House. Round them all up, because you either lock them all up or let them out. Because, like, what are we doing here? What are we doing here? What message are we sending victims that now that we are doing everything to protect these PDF files? I don't get it. I just don't get it. I think our freedom of our rights are being trampled over. Like, they're doing all sorts of things to, channels and things like that. People that are speaking up for victims, depending on what platform you're on. They pick and choose like who they want to mess with. But at the end of the day, I just have no understanding. Ghislaine Maxwell, she is not a victim. She's not a victim. And I just don't understand, because we have somebody that's having a tantrum, that's going on 5-year-old rants trying to protect what is clearly out here in the public that we can see. They want us to unsee what we see, and everything is AI now. And so it is sick that what's going on, in right now in this country. It's sick. It's sick. And these victims, these Epstein victims, said that Ghislaine, she was worse than Jeffrey. She was worse than she was worse than he was. And this is the victims that she victimized. She didn't just recruit girls. She also participated in the essay of these girls. What are we doing? Why is she what? In order for them to move her, they had to commute her sentence from a max. Her status had to be changed from max to minimum, or they would not have been able to move her. So because we have somebody having a tantrum over here, her status now went from maximum security to minimum security, and they moved her, and now she was moved again today. And now she's at a very minimum security building. She's not a victim, though. And, my prayers and, heart goes out to these victims. And, her first name is, I think it's Jennifer. Is it Jennifer Goofrey? I think it's Jennifer Goofrey or Jessica. I don't want to butcher her name. I do know her last name is Goofrey. Was an Epstein survivor who was trafficked from Mar-a-Lago by Epstein and Ghislaine. She was working at the spa in Mar-a-Lago and trafficked to by Ghislaine and Epstein, and they started to traffic her, and unfortunately, allegedly, she unalived herself, and so it's just crazy. It's crazy to protect somebody's image. We are re-victimizing these victims. It's crazy. No, Allie. So I was talking to you, and I looked over here, and I was like, "What is going on?" I don't know if it was. I don't know if it was the restream that wasn't connecting. And I'm like, wait a minute. I'm talking, and I saw you in Pisces, and I'm like, wait a minute. Yeah, I don't know. But anyway, we got this piece of crap here, Jarvis Butts, who had a hearing today, and like I said I said before, I had started the video. I wish that this judge would tell this guy, sit up, hold your head up, and be the bully that you were, when you were victimizing these victims. He comes into court like he's shrinking. He's like he's so fragile, like he's a victim. And take this mask off. You're the only one in the courtroom with a mask on at this point. You're using this mask as a shield. Because you take the mask off, sit up straight. He's a coward. And you'll see how he's trying to position himself in these hearings. When he comes in, when he walks in, he's the victim. And I just think that they need to, like the first judge told him when we were going through, when he had the preliminary hearing, sit up straight. Sit up. Hold your head up. Because you need to hear what I'm going to say to you. I just want him to be the bully that he was when he was victimizing these girls. But let's get into this. Like, we got to start this over because I don't know what's going on. It's just crazy. He's the victim.
We're calling cases 24-002-236.
Exactly. Hold your head up.
25-000-218. And lastly, 25-000-241. These are all in the matters of People versus Jarvis Butts. I apologize, I believe I missed one. There's also file 25-004-478. Can I have appearances? Let's start with the prosecutor.
Good morning, Your Honor. We have People P83688.
And good morning, Your Honor. Matthew Makepeace, also on behalf of the People, P82796.
Defense.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973, on behalf of Jarvis Butts, together with co-counsel Ken Riggins and Lauren Butler.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. Jarvis Butts.
Good morning, Your Honor. Lauren Butler, P88126, also Neighborhood Defender Service, on behalf of Mr. Butts.
Thank you. Mr. Butts is also joining us in court. Mr. Butts, your name, please.
Jarvis Butts.
All right, thank you. You can all have a seat.
I can't.
Thank you for your patience this morning. We did have a short chambers conversation about these cases this morning. And just to briefly summarize defense, you intend to raise an issue with regard to some outstanding discovery on the case ending in 218, which has the homicide charge. Is that accurate?
That's correct, Judge.
All right. It's also my understanding that there are two motions to quash filed today.
Yeah, that's what we watching it from. I think that same channel. Yeah, click on Detroit.
Okay, very good. All right, well, let's start with the file that Mr. Butts is here to be arraigned on, that being the file ending in 4478. How does he wish to proceed for the hearing process?
Yeah. Mr. Butts would waive the formal reading of the information. He stands mute. We ask the court to enter a plea of not guilty on his behalf.
Thank you. A plea of not guilty will be entered on his behalf. Counsel, was the examination held in that matter?
It was.
All right, we're going to get that transcript ordered. And with that, do you want to move right into the respective motions to quash, or did you want to address the discovery issue?
I think we can go ahead and do the motions, and then we can discuss the discovery at the end.
Okay, very good. All right, who's going to take the lead from the defense?
Your Honor.
Very good. Your motion.
Your Honor, thank you. So, Your Honor, I did file a motion to quash relating to case ending in 6232. For the sake of privacy, I won't mention the complaining witness's name. But, Your Honor, there was a preliminary examination held in this matter. There was one witness called. The complaining witness was the only witness called. She testified that at the time of the incident, she was 4 years old. At the time of the hearing, she was 13. So there had been a substantial passage of time. Your Honor, her testimony was she was home with Mr. Butts and Mr. Butts' girlfriend. At some point, the girlfriend left the bedroom. Mr. Butts was in the bedroom. She was on the couch. Mr. Butts summoned her to the bedroom, at which point she was ordered to take off her clothes. Her testimony was she took off all her clothes except her underwear. She took off her clothes. Then Mr. Butts touched her. I believe the order of touching her was he touched the top of her thigh, then he touched under her breast. And then she said he touched her.
Is that the lady
where
that
she
got that essay?
That was the sole testimony of this witness. At the end of the proofs, prosecution moved to bind over on an original count of criminal sexual conduct in the second degree and added a count of criminal sexual conduct in the first degree because of the statement of because of the statement of complaining witness. Your Honor, we believe that is an abuse of discretion. The only thing that we have on the record is she said she touched where she uses the restroom.
So do you hear, like, I'm so bothered by, and I get it. I get it, but I'm so bothered by a 4-year-old, that victim who's now 13 and still a child, because I just don't, I wouldn't be able to do it. But I'm wondering, the reason why I'm stopping this lady, y'all see this lady back here sitting behind with her head down? Is that the lady that SA'd him? She looks like her. He was SA'd as a child, and he has a child with the woman that SA'd him. He also SA'd that child. And that looks like the lady. That looks like her. She's older than him. And that looks like her. I'm gonna have to go over there and see if Shank talk if Shank Rock talked about that. Because that looks like her. Oh my goodness. Y'all, I'm gonna have to see if that's her. If it is, this is sick. Oh my goodness.
And the only clarification we had was she said this is where she pees from, or she urines from, excuse me, those were her words.
That's something that a child would say.
Prosecution postulating that meant that there was some penetration, except there was no penetration mentioned. There was no penetration discussed. We know from case law,
penetration does not have to be with his private parts. That's something that a child would say. Are y'all confused? She said he touched her where she urinates from. But she said the P word, pee. That if she touched him there, And you're going to argue that, oh, if he pushed her panties up there, she didn't say he pulled his. This was a 4-year-old freaking child that's now 13. It's clear to me what she's saying. She's answering the way a child that shouldn't be touched would be answering this question. I'm confused as to why he's confused. And I guess he's trying to look at the very small people. I'm not confused. That's clear to me, because we all know what he touched me where I be at. Okay, so in order for her to touch, I don't know. I don't know if it's just me. I just know we need to just send all of them over there. Send them all to a Kendrick Lamar concert and line them up, because he's going to take them out. He's going to take them out because he can't stand these type of people. So that's what we need to do. Yeah, he put that on wax. He said that Weinstein and Drake don't come for me, because you got all your little minions running around here doing all. Listen, it's the song. It's the song that you are now trying to. I just don't understand that you are trying to do what you're doing to hip hop. But I'm gonna make another video about that, because I'm gonna. It is just a shame. You mad because you lost the battle, and so now you suing, and now they are actually. If this is bad for hip hop, if this pushes through, it's censorship, because you don't have any skills for real, and you're a culture vulture, and hip hop is back. Shout out to Kendrick Lamar. And so we'll talk about that, because I'm just so intrigued because of but let's get back to what that was on.
There has to be some form of
just come out here,
even the slightest.
Put them all together.
Case law also tells us, if she testified that he were to force her underwear inside of her, that would be sufficient for penetration. Yeah, we don't have any of that. We never have conversation, or we never have any testimony about her panties being pulled aside. We never have any testimony about her panties being forced in her. We never have any testimony about anyone penetrating her. Now, that is given the fact that she was 4 years old at the time this happened. Granted, but at the time of the hearing, she was 13. Surely she testified.
She got the STD to prove these things. At 4 years old, what does this 4-year-old child, why does she have an STD that he gave her? He clearly had to, in order for her to be diagnosed with that STD, he had to. How else she got it? It's not. She didn't get it from. How did she get it? How did she get it? They talked about this before. This is the 4-year-old that he gave the STD to. She's now 13 years old. How did she get the STD? At 4 years old. I'll wait. What is he talking about? And I don't understand why because she didn't say she pushed her panties. She's 4 years old, for Petey's sake. Because she's 13 now, that changes things? No, it doesn't. She's still a child. Some of these men, these women sitting here, all this, I wouldn't be able to do none of this. I would have been socked him in his face already. I'll be in jail. Oh, Jarvis bus lawyer done went to jail. Didn't pass go. Went straight to jail.
I believe she was asked on the record that she remembered the events. She said she remembered the events. None of that was testified. I think to say that there was sufficient evidence on the record that says that there was a penetration for the purpose of the CS1 is an abuse of discretion, and we believe that should be dismissed.
Thank you. And counsel,
Yes,
your respective motions, they're similar in nature in that you're arguing the issue of whether or not there's sufficient evidence on the issue of penetration. On
Oh,
both
this
your
is
motions.
always. I haven't
Right.
been doing anything. Life has been
Why
like.
don't we have them argue
I don't really want
the
to.
second matter, and then we'll hear one response from the
I'm
people.
trying to
Okay.
get back into it.
That's fine.
Okay.
Okay, so this is then with regard to the case ending in 24101, and, sorry. Okay, and this is Lauren Butler, P88126 again.
Thank you.
So first, to overview the facts from that case, I want to emphasize that this is only with regard to one of the two instances described. The complainant described two instances, but only one of them has been charged as first degree. And I am only arguing with regard to that and that particular charge. So at the preliminary exam for that instance that was described, the testimony included wearing panties. So again, that is similar. She never described those being removed. She did not describe any instances of penetration and only described light touching while wearing panties. The prosecution had the burden at the exam of establishing evidence of every element, and that included penetration.
Minimizing trauma
And again,
now.
the case law is clear on this. In particular, the case I cited in my motion, People v. McNeese, while that is unpublished, it is particularly relevant because it highlights this distinction
Like touching.
where it needs to be more than just, it uses very similar language to that used at the exam here with this emphasis on touching the vagina, rubbing the vagina. That's not enough for penetration. And there was even a
What the f- is she talking about? Light touching. What a way to minimize the victim, a victim's trauma. Light touching. Were you there? Were you there? This is disgusting at best. I don't care. I get it. He's innocent until proven guilty. But what are we talking about? What light touching?
specified testimony about under the underwear and over, and yet even with that fact, the court still held that this was not penetration. And that's similar to what we have here, this description of some degree of touching on that area, but that alone is not penetration. It also relies on published case law, People v. Payne, rubbing one hand, where it concludes that rubbing one hand over another vaginal area does not qualify as penetration. And I'd also like to address the response from the prosecution to this motion, because the argument they're making was not reflected in the preliminary exam testimony. Specifically, there was no testimony about inside the vagina. So while they're now arguing that that is possible, it's not the testimony we heard. We didn't hear this contrasting of the labia and the vagina. And this diagram that is now referenced in the motion was not used in the exam. So in conclusion, the prosecution did not meet the probable cause standard for first-degree criminal sexual conduct because there was no evidence of penetration, and bind over was not proper, specifically as to that charge.
Thank you. All right. Who's going to take the lead from the people?
That's me, Judge.
All right. Very good.
So I'll start with the first argument made by Mr. Riggins, the complaining witness there, reference her by initials, PB. She testified specifically that he touched my private part where I use the bathroom with. When asked what comes out, she stated urine. I then asked, tell me about what part of him touches you there. She states his hand. And what does he do? What does his hand do when he touches you there? He states he rubs my private part with his hands. I then clarified, is this on the top part of that? And she interjected, said the bottom. And I said, would that be where the pee comes out? She says, I clarified, is that a yes? So in summary, she testifies she's rubbing the bottom part of her private part where the pee comes out. Your Honor, in a motion to quash, this is the highest deference to the reviewing magistrate in this case. It requires an abuse of discretion, which is most deference to the district court. Penetration requires any sort of intrusion, however slight. And we use the term genital opening rather than vagina, so that penetration of that labia
Got
majora
that
is
mask
sufficient
right
to
up under his
establish
eyes.
penetration
the mask
for
off.
criminal sexual conduct in the first degree. Here, the complaining witness testified that the defendant rubbed her on her bottom part where the pee comes out. When we think about basic anatomy, we know that pee or urine for women comes through the urethral opening. There's a lot of, biological anatomy down there, but we know that the urethral opening is an internal structure that's beyond both the labia majora and the labia minora. So when this complaining witness testifies that he rubbed her bottom part where the pee comes out, she's referring to an internal structure, thereby penetration. The examining magistrate also found that, and said in her ruling, that for a woman to urinate, it's not on the outside of her labia. That's an internal. It would be beyond that. And so she found that it was a question of fact. I don't believe that there's any abuse of discretion by that. I believe that there's satisfactory testimony, at least to a probable cause standard, for that count. And do you want me to go on to the next one?
Did you see him look at the?
In the second case,
Did you see him look
extremely
outside his
similar.
eye?
This one is specifically.
Howard.
This complaining witness starts off by saying, you know how somebody would play with you in your sleep, like you would feel them in your ear, like this or something. We don't have what she was demonstrating, but she's playing with her ear. He was doing that to my vagina when I woke up and I was crying. I stated, all right, when you wake up to feeling something? She said, yes. I asked, where do you feel something at? She says, at my vagina. And I said, what do you feel at your vagina? Should I feel like somebody's playing with me? Like, I don't know, like somebody's trying to touch you but not wake you up while he's touching you. And I said, what part of him is touching you? She said, he's using his hands. She later confronted the defendant about it. He's asked her why I was acting so weird towards him. She said, you don't remember what you did to me? He, the defendant, looked me dead in the face and said, I don't remember doing that, but if I did do it, then I'm sorry. Again, the reviewing standard is abuse of discretion.
Exactly, Allie. Exactly.
Here, similarly, she testified that she felt the defendant at her vagina, that she felt the defendant playing with her, using his hands at her vagina. It's more than just mere contact, mere brushing against a vagina, or just merely touching on top of it. It's an intentional act at her vagina. By stating she felt the defendant's hand at her vagina, she's testifying to penetration. She did not state that she felt his hand on or over her vagina, but rather at her vagina. Again, we look at basic anatomy, Judge. The vaginal opening is beyond beyond or inside both the labia majora and the labia minora. And so because sexual penetration is defined as the labia majora and beyond, the vaginal opening is beyond both the labia majora and minora. And so by stating that she felt the defendant's hands at her vagina playing with her, she testified to penetration. And I believe that there is satisfactory testimony on the record to satisfy that to the probable cause standard, which is, again, probable cause standard is the lowest standard, and abuse of discretion is the highest deference to the examining magistrate. And I believe that they both create questions of fact.
Thank you. Did defense wish to respond?
Your Honor,
This mofo.
in all seriousness, we're giving far more biology of the human anatomy than has been put on the record at the preliminary examination. All we had at the preliminary examination they were touched at the area. We have young ladies who, although at the time this happened, may have been too young to describe the actual part. At the time of the preliminary examination, surely they could have said, he touched me on the inside. He forced my panties aside. He touched me on the inside.
Really?
And in either case, was that testimony ascertained, that testimony was given, that question was asked by either people. So here, all we have is
Really?
hyperbole. This is what the complaining witnesses must have meant when they said that. Yeah, and I think that is a far-reaching.
Oh, the fuck! Like, what the fuck are you talking about? It doesn't make a difference whether they were 4 or 13. They're still children, and he should not even have had his hands lightly touching them in that area. What the whole entire fuck are you talking about? Oh my gosh. You are really sitting there and you are what, because she's 13 now and came there and she didn't clarify what the
I think surely that is an abuse of discretion to just simply say they must have meant there was internal penetration. That is an element the prosecution has to prove in each and every case when they charge a CSD in the first degree. In neither case was that proven, was that ascertained. We just have speculation, and to put those charges in front of the jury would simply be wrong, Your Honor. So we're asking you to grant both motions to quash.
All right, thank you. Do you wish to respond?
Judge, I would just reiterate what he is already saying. I think in my case in particular, there's this emphasis on the word at. There's just no, it's not realistic to say that that's what at means. This comparison between at and over is really not what plain meaning tells us about the word at. At is very different from inside.
All the rest of the testimony. She said where she sees that.
All right, thank you. All right, well, on a motion to quash, there's 2 motions to quash that have been filed by defense. The court has to review the record for an abuse of discretion, which has already been pointed out. The abuse of discretion standard is a high burden. And defense here, through their written and oral arguments today, have challenged the sufficiency of the evidence presented on the bind-over of the respective counts of criminal sexual conduct in the first degree regarding the issue of penetration. So the court has had an opportunity to listen to the respective arguments from the attorneys here today. I've also had an opportunity to review the lower court record, and namely the transcripts. And of course, the prosecution at the preliminary examination has a burden to show competent evidence that probable cause exists on each of the elements of the charged offenses. So here, looking at pertinent portions of the transcript, and I'll start with the case where PB is the alleged complainant. There's a few pertinent portions of that examination transcript, starting on page 58. And it notes line 20, her answer to a question, he touched my private part where I used the bathroom. Question, okay, and when you use the bathroom, what comes out? Answer, urine. Question, urine, okay, tell me about what part of him touches you there. Answer, his hand. Question, on the following page, okay, what does his hand do when he touches you there? Answer, he rubs my private part with his hands. Question, okay, was this, so when he's rubbing your private part with his hands, is this on the top part? Answer, the bottom. Question, the bottom part, okay? Answer, yes. Question, okay, and is that would be where the pee comes out? Answer, yes. With regard to the file where the alleged complainant is AD, and directing the attorney's attention
really,
to
Allie?
the pertinent portion of
Yeah, I don't know what's
testimony
going
issue
on. Oh, you know what? I
penetration,
could
page
have
83, line 14. This would be multiple paragraphs
I
into
should
the
have.
respective answer, reading. And
Well,
you know how
you're
you
welcome.
like how
Let me
somebody
see. I think I got
play
something to give out. I
like
haven't even been on here already.
them. And I think the pertinent part of this answer that's relevant to this determination is the next 3 words. And again, it's like you would feel them, quote, in your ear, like this or something. He was doing that to my vagina when I woke up and I was crying. Moving to the next page, page 84.
I don't.
Question, okay, where were you sleeping? Answer, I was sleeping in the bed with him. Question, you were sleeping in the bed with your dad?
I do.
Answer, yes. Moving to page 85, line 8, question, all right, and when you wake up, you kind of wake up to feeling something. Answer, yes. And where do you feel something at? Answer, my vagina. Question, what is it that you feel at your vagina? Answer, I feel like somebody playing with me. Like, I don't know, like somebody like trying to touch you, but trying not to wake you up while I'm touching you. Question, okay, and do you know what part of him he is using to touch you? Answer, he's using his hands. So sexual penetration is defined, that's defined under 750.
So shout out to all y'all. Just they give us free memberships, and I wonder if I forfeited my memberships from last month. I wish I would have knew before you did that. I don't know if they would get. So YouTube chooses the people that they give the memberships to. We don't have the option to choose, but they do give us 10 a month, and even if somebody doesn't come in here, they have. So thank you for that. For renewing your membership, Allie, and reminding me, because I forgot I do have those to give out. Because I wasn't, life been life, and I just, it's just a whole lot being a caretaker, like it's, and then just life on top of life, and still waiting for the insurance company, still got a hole in the roof. Just all that just the sometimes I'm like, at night I'm like, wait, do I hear something up there? Right, they came out and professionally tarped, like they sent the company, but I don't understand why it's taking so long for them to finish with the claim. But yeah, life is life, and so shout out to the people that received the memberships. I don't know what YouTube is on. Like I said, I haven't been on here doing any live streaming. But I am, because like we gotta go. I'm gonna, like, when I finish this, I may go live again, because I really want to talk about, because it's true crime. It's true crime, the way Kendrick Lamar is out here whooping the people out here in the industry. And I want to talk about that. And I want to talk about lawsuit that Drake has, because he's a sore loser. I'm calling it is what it is. I really wanted to get into that, and how his lawsuit could possibly censor. He's calling for the courts to censor the hip hop, because he lost a rap beef that he started, and you poked the bear, and you just, so we're done with the cut and paste hip hop culture vultures. You got to work for what it is that you want in this industry, and he's so bothered. Go get in the booth. Oh, I forgot. You ruined all your relationships, so your ghostwriters, you don't have any right now. That's another video. So let's go here, and I'm gonna go back there, because when I tell you, I'm just, Kendrick Lamar and SZA have me in a chokehold, like right about now. And I just think it's a beautiful thing that's going on for him, and and I'm gonna do a video on it, because the way. Oh, okay. We're gonna do this first. I'm
520AR, sexual intercourse, cunnilingus, fellatio, anal intercourse, or any other intrusion, however slight, of any part of a person's body or of any object into the genital or anal openings of another person's body, but emission of semen.
Get him out of here. I hope he does the right thing.
Based upon my review of the lower court's record, testimony utilized in making the bind-over decision, I think based upon the testimony that I just read in the record verbatim, the examining judge did not use her discretion in binding over on respective counts of criminal sexual conduct in the first degree. I think there was sufficient evidence presented on each of the elements, and specifically the element of penetration in both files, to uphold the bind over, and attorneys are going to respectfully deny the motion to quash. All right.
Shout out to you!
Attorneys, you have a couple of other issues to discuss.
Oh, he is crying, Alan.
Would you like to get into
Yo,
the
what
discovery
the?
Sure.
issue that was noted earlier?
I can pick that up.
I better get
CSLI that was used at the preliminary exam. Prosecutor posits puts Mr. Butts at the scene of where certain pieces of evidence were located.
And so we're clear, counsel, you are moving into the file ending in 218, correct?
Yes.
Okay, thank you.
Apologize. Thank you.
That's okay.
Back on February the 6th, Mr. Riggins reached out to the people and alerted them that our expert to review it, we needed was the Cellbrite UFED, basically the underlying data that is pulled, not the report that is generated from Cellbrite.
What was the date that was put on notice?
February 6th.
February 6th. Okay,
Yes.
so just about 6 months ago.
Correct.
Okay.
And then we received a response back on the 14th from people saying that they would work on it and get back to us. We received another response on the 28th that they were looking for the files, essentially discussing that it's a huge amount of data that has to be transferred. And then we followed up, it was sometime later. And the next response I have is from May 28th, that there would be follow-up with the right person at DPD. They would get back to us. So we've been in communication with the people about this for this entire time. There's no surprise that we've been asking for it. And the response has generally been either that the DPD has it and they're working on transferring it, or that it's taking a really long time to do because the data is so great. They have to basically go through three different, they take it from a hard drive onto another thing that can be transferred, put it on ours, and then they can send it to us. And as of this morning, we still don't have it. We are less than 2 months out now from trial, and given this amount of data, we have to have our expert look at it. We are very concerned that we don't have it yet.
Understood. So we the file set in that file. I've got it set for October 6th, so we're just north of 2 months by my math. So, Mr. Makepeace, did you wish to respond from the people's perspective? Why has this taken so long when it was put on your notice 6 months ago?
Yes, Judge. No, and I'm not disputing the dates or the emails that Ms. Quick referenced in the responses. There was a period of time where we had kind of, because it is an unusual request for the underlying file. They do, for the record, are in receipt of the cell phone forensic extraction reports that are generated, which are the files that are usually turned over. Those are UFDR files. This is the underlying file that comes with that or is generated and then put into a report. They have requested that on the dates and times. There was a period of time where I had to communicate with the OIC as well as the cell phone expert at DPD to figure out exactly what they were asking for. That did take some time, and then there was a period of time where I requested from the defense a hard drive that they provided to us for these to be uploaded onto. That hard drive, and I don't have the exact date in front of me, was turned over by Mr. Riggins to me. I transported that hard drive to the Detroit Police Department and provided that to the officer in charge of the case, as well as with the understanding that she and the cell phone expert would get together and get this uploaded. That's where I think the biggest delay comes from, is that there was a little bit of a miscommunication to them, between them, on our side of it, which is that one said it was done, one said that the other person did it, and nobody actually ended up doing it. When I went back to pick it up, it wasn't done. At that time, I brought the hard drive back to DPD and said, this needs to be done as quickly as possible. That was within the last month or so. The actual process for them to upload these or get the files onto the hard drive is to take it from a Blu-ray disc or a DVD onto a computer and then onto the hard drive itself. That does take some time, given that there are, I think, 15 or so phone dumps that they've requested these files for, and the amount of information is large. As of this morning, I spoke with the cell phone expert who is in the process of doing this. He states that it will be done middle of this week, Wednesday. And at which point I will myself go to DPD, gather the hard drive, and provide it directly to Mr. Riggins or Ms. Quick or Ms. Butler.
Okay, so you believe you will have it to them by the 6th?
Yes.
Okay, which is exactly 2 months out from our trial date. All right, why don't we schedule an additional pretrial date for all files and bring it in to hash out any potential trial issues and things of that nature. Also noting the people did file a notice of other acts. Which files which files did you file?
Judge, I filed that on all of the cases except for the newest one because that one wasn't in the system yet. So yes, there should have been 4 filed as of last week.
Okay.
And we do intend to file an objection.
Yes, Your Honor.
All right. Very good. So why don't we schedule a date to hear that? Are you anticipating filing a notice on the case Mr. Buck was arraigned on today?
Yes.
Yes.
Okay. All right. Defense, how much time do you want to respond?
2 weeks.
Okay.
I apologize. Mr. Riggins is out of the office for one of those next 2 weeks. So if we get a 3.
Why don't you come back on Friday, September 5th?
Judge, I'm I'm off that day. Back the next Monday, though.
Is this something, Ms. Ripley, that you would be able to handle in Mr. McPeace's absence? If not, I can find another date.
It is, Judge, but I'm going to be in a 2-defendant homicide trial that starts on the 2nd. And it's in Judge Cusick, so I anticipate it going on Friday.
Okay, understood. What if we come back on Friday, September 12th, mid-morning?
If we could come after my exam, that would be good for me.
The 12th is not a good day.
The 12th is not a good day.
I could do the 11th. That was good.
Strictly on the 11th?
I'm going to be in that 2-defendant homicide. Is it the 15th or the 16th? I know that's cutting close. We're starting to cut close, but
I think we could do the
How about
15th.
Tuesday the 16th? Does that work for everyone's
That
calendars?
seems to work. Yep, that works.
Right. Okay. We'll come back Tuesday, September 16th to listen to argument on the other acts. Notice that the people have filed. Let's set that hearing at 10 a.m. All right. Were there any additional issues that needed to be talked about or addressed from the people's perspective for today?
Judge, no additional issues. As I would in any case, I would just place on the record an invitation for defense counsel to come to our office to go through both paper and digital files to make sure that there are no other surprises. Just place it on the record. Ms. Quick, Mr. Riggins can communicate with me to set that up.
Absolutely. And as noted in chambers, when we set our October trial date, it was far off into the future. It was far off into the future with the, of course, the intent that all parties would make sure that they're doing everything
I hope
possible
we
to
ain't
make sure
crying, y'all.
this is the trial ready
You
for
cannot
October the 6th.
possibly be the
This
freaking
time
bully
around,
that he
Friday,
is and sitting there crying. I'm just not going to do that. I think that's so.
Pre-trial date, again, Tuesday, September 6th.
You got to put cold in his
Additional
eye.
issues that defense needed to address for today's record.
I don't believe so anymore.
Very good. I thank you all for your time and patience today.
Thank you,
To conclude our record.
thank you, Judge.
Thank you, Judge.
Thank you.
All right, so there's the loser. So it looks like they schedule they have a another court date, and I'm so glad that the motion to quash, especially them trying to minimize the victims trauma. I like I said, I wouldn't be able to do it. I just think that the judge should, and I guess they don't want to bring any attention to it. Like, they don't want to give them any reason to be able to appeal something. But I think that it's proper to tell, somebody that's in court to sit up. sit up and act like you are, like you be a part of the case. You're no victim. Sit up, man up, because this is what you did, right? But anyway, I'm glad that they, that didn't work out for them. I'll try to stay on top of when they do, come back for those, that other, the hearing that they're going to have. Oh, really? So yeah, to see where that coming, because the trial is starting. The jury selection is starting on October 6th. There is a case that I did want to go. I did want to just. I don't want to go over the whole case, but I did want to go over. And I just wasn't able to, get to that the Queso trial. I wanted to go over the Queso trial, just certain testimony. Right. I did watch the testimony of the father. The father and the friend. The two people that are implicated in more than one unaliving. Getting deals. The friend's testimony bothered me so much. And they're expert. I don't know if, and that's why I said I was just going to go over those. I wanted to just look at that. The testimony from the father and from the friend Barner. That's the father's commits crimes with. And a little bit of the expert testimony. The guy that did the hike, that did all this, he needed to have whistles, bells, chains, hooks, links, metrics to measure how tall somebody is. And he was asked, if I have him stand up now and we get a straight ruler, will you be able to tell how tall he is? No, oh no, I would need to do. What are you talking about? For me, I didn't think that the picture that they had of the unaliver running in Queso, I thought it was two separate people. He was not skinny like that when he was arrested. He had a belly and everything. You could clearly see in that video. It didn't look like it was Queso. It didn't look like, and then the expert had him at, he had 3 different heights for him. You're the expert. You sent your people here. $30,000-$40,000. What are we doing here? I just thought I just wanted to. I am going to do that. You're welcome for always. I am going to do that because I just want to look at that testimony from that time. I'm not going to go through the whole trial for that. But if you are here, please hit the like. Thank you so much, Allie. Shout out to you for the 5. Thank you so much for always supporting Baby A. Kiss Baby A for me and tell her I said thank you. And so yeah, so okay, I wanted to go over the trial because it is the audacity for me. And when people talk about snitching, this is a case of, because everybody just be running around talking about somebody snitching. This is a perfect case where you can say that, where you can apply that with. People got together, you did a crime because you got caught and you wanted to get out, so now you don't even care. You just in here telling about somebody up the river, and there's nothing that you can do nothing that you say they will be able to use you, and you're gonna get less. This is a perfect example of somebody that's like that snitching. If we all doing a crime together, and then I get away, and this is a perfect example of that. But when people don't know what's going on, you put somebody in an awkward position. That's the difference. It's just that we just need to, people need to stop using the term so loosely. But in this case, this is a perfect example of that. And I don't know who raised these BANs out here in these streets nowadays, because queso father, you a whole BAN. I got diabetes and my foot in the left, and that that's him. That's my son. You ain't even raised your son. I can't take it, y'all. But I'm gonna go out. I'm gonna come back. I'm gonna schedule a live because I really want to talk about the Drake censorship, because that's what it is. The case that he filed because he lost a rap beef, down bad, and just being a sore loser. Get in the booth. Get in the booth. You can't. But I think it's just crazy. But anywho, so I'm gonna schedule that. I'm gonna come back. I'm gonna talk about that a little while, and I'm probably gonna react to see if they copyright strike me or not. But they shouldn't. I think Kendrick is like not copyright striking. They lift the copyright strike so that people can review the music, which I think is pretty dope. And he just got me in a chokehold right now. And hip hop is back, and I do want to talk about it. So thank y'all all for coming out. I'm gonna go and set up something. I probably will be back probably like in a half an hour or so, depending. And thank you so much. Shout out to everybody that got new memberships or re-membership. Thank you for renewing your membership. Thank you, Baby A, for the 5. And I'm going to go and schedule that live, and I will be back probably about 30 minutes. Because I really want to talk about this because it's really heavy on my brain. But if you're not into hip hop or whatever, I don't know, but I want to talk about it because we need to talk about these BANs out here. It's bad. It's crazy, but it's a beautiful thing at the same time to see it. And so I'm going to yeah, nobody's raising them. Yeah, so I'm going to go out, y'all. Thank y'all. It wouldn't be me if I didn't end the show by telling you and bringing awareness that men can get breast cancer too. Because of the stigma surrounding the word breast, we've changed the word to peck and or chest cancer over here on the Survivor Speaks channel. We're going to continue to bring awareness to the fact that men get breast cancer too. Go over there and sub up to my channel, Survivor Speaks 2.0. Life been life, and I should be putting content out over there every day, but listen, it's just life be life, but I'm trying to get back into the swing of things, and so go over there, sub up over there to Survivor Speaks 2.0. And thank y'all for coming out and showing your love and support. And I'm going to go live in a minute, just probably about 30 minutes. Change my battery and everything is about to die right about now. So I'll see y'all if y'all come back and join me in the live. And let's talk about this Drake and Kendrick Lamar thing real quick, because it's bothering my soul. All right, y'all. So thank y'all for coming, and I'll see y'all in a minute. Peace. Survivor Speaks is the name at the end of the day. People love me or hate me, I don't care either way. Breast cancer busted through like a leaf in the night. A cancer's ass was knocked out before the end of the fight. A champion coming through, knocking everything out. It's just hard if you see, I do nothing for clout. Just like cancer, I'll let nothing take me out. So be respectful when you step foot inside of my house. Hold it clear to have your ass escorted on out. So hop up out the bushes, wipe your feet, take a seat, and get comfortable and chill with your girl. Survivor Speaks, yeah. Hey, hey, hey. Who, what? I'm survivor, speed. What time is it? What time is it? What time is it? It's time for you to hit that like and subscribe button and turn on that notification bell so you get a notification each and every time that I go live. Yeah.